This is a lecture for my professional responsibility course. We're going to be talking about Rule 1.13 or 1.13, having an organization as a client. So let's take a look at the rule. Now, I want to warn you, this is one of the longest rules out of all of the ABA's model rules. So it's kind of in the top three along with 3.9 and 1.8. And so we're going to have three separate videos going through the different provisions in this rule. And in this one, we're going to be talking about just A, 1.13a, organization as a client. A lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. This is our whole rule, but notice I put in bold that the lawyer represents the organization. When you represent a corporation, let's say, if you think about it, and it could be a large nonprofit like a hospital or a university, or a big mega church, or it could be a for-profit like a corporate entity. And so think of big companies. There's a lot of people that work there, and the constituents could be the different managers, all of the employees, right from the top all the way down to the lowest level, entry-level employees, and so forth. At a nonprofit, it could also be board members and things like that. And so the question that comes up in practice is, who is the client? Who is the client? The other thing I want to say before we start going into the comments about this rule is, you may remember that we've encountered this with two other rules in our lectures. On 1.7, the main conflicts of interest rule, has a section of its comments near the end that talk about representing corporations and the types of conflicts of interest that can come up for attorneys when they're representing large corporate entities, and especially when lawyers are trying to serve on the board of directors for a corporate client. And so the lawyer kind of has two roles. They're a board member and the legal counsel for this entity and the types of conflicts that creates. We also talked about representing organizations when we talked about attorney-client privilege. We have a whole body of law, attorney-client privilege law and work product law that deals specifically with corporate clients, where it gets very complicated about which people in a corporation can the attorney have a privileged conversation with. So here, though, in 1.13, we're going to be keeping all of those things in mind and then looking on. Now, an organizational client, this is comment 1, is a legal entity, but it cannot act except through its officers, directors, employees, shareholders, and other constituents. And so these officers and directors and employees are the constituents of the corporate organizational client. And so the corporation is sort of a legal fiction, right? It exists on paper legally, and then in the real world, we might think of corporations as their assets, like the building where they operate, and their stocks and the employees and the workforce and so forth. But that legal entity, that corporate person of the corporation, has to act through some sort of real live human being, and that's typically going to be the director and the board. Now, if a constituent of an organizational client communicates with the organization's lawyer in that person's organizational capacity, the communication is protected by Rule 1.6. That's our confidentiality rule, our duty of confidentiality. This is comment 2 to Rule 1.13. Now, I want to remind you that it may not be privileged, and I'll have you point you back to the Upjohn versus United States case, and where it set out some guidelines about which conversations that a lawyer has with constituents in a corporation are privileged and which ones aren't. And this is a difference between privilege and confidentiality. So if you're representing an entity, and it could be because you're in-house counsel or you're outside counsel, any conversations you have with an employee, a constituent, a contractor for that company, a manager, you have a duty to keep it confidential. Your duty of confidentiality applies to those conversations, whether or not attorney-client privilege applies to them. And then here's the example, and this should remind you of the Upjohn case. If an organizational client requests its lawyer to investigate allegations of wrongdoing, interviews made in the course of that investigation between the lawyer and the client's employees or other constituents are covered by Rule 1.6, which is the ethical duty of confidentiality. That means the things that you hear from different employees in the corporation while you're doing an investigation or an internal audit, you shouldn't share with the world. All of that information is going to be confidential because it came from you representing the entity. On the other hand, and this is very important, the constituents themselves are not your clients. The constituents yourselves are not your clients. And this is going to create two types of problems that I want to point out to you. Some of the people, usually the managers of the corporation, may treat you like you're their personal lawyer. Why? Because they treat everybody who works there like the person works for them. And so watch out for that the manager is not necessarily your client, the entity is. And your duty, as a lawyer, is to the entity, not to a higher level person who works there. On the other hand, sometimes you have lower level employees who just assume that you're looking out for them because you're the lawyer for their employer. And as you know, sometimes that's not going to be the case. And we'll talk about that more when we get to some of the later provisions in 1.13. Now, an implication of this is that even though you have a duty of confidentiality from the information you learn from constituents, that also means that you don't get to tell other constituents what you hear as a lawyer. So the lawyer may not disclose to such constituents information relating to the representation except for disclosures explicitly or impliedly authorized by the organizational client in order to carry out the representation, or as otherwise permitted under Rule 1.6. You may remember the confidentiality rule has a number of important exceptions. And so if those apply, then you may be allowed to make a disclosure. So what this means is, let's say you're representing a large company like Shell Oil or General Electric or Microsoft, and you happen to meet some employees there who maybe you're friends with, or they park next to you in the parking lot or something like that, and they ask you, hey, what's going on with our big lawsuit? You actually have a duty not to tell them, right? So even though they work for your client, they are not your client. Information, if they tell you something, you have a duty to keep that confidential and tell whoever is directing the corporate client about it. But these individuals, you're not working for them. You work for the entity. And that means that you can't just update everybody casually on what's going on with litigation, or what's going on with the patent application, or what's going on in our negotiations with the government regulators. That's for the people that direct the corporation, who have hired you. They are acting as the representatives of the entity. But all of the employees or other constituents or contractors are not your client. Okay, comment 3. When constituents of the organization make decisions for it, the decisions ordinarily must be accepted by the lawyer, even if their utility or prudence is doubtful. Decisions concerning policy and operations, including ones entailing serious risk, are not as such in the lawyer's province. And so sometimes as a lawyer, you're going to be sitting in meetings because you're either in-house counsel or outside counsel, where you're going to hear the management talk about their new idea or their new product line or something like that. And you're going to sit there thinking, this is the dumbest thing I've ever heard. I can't believe they think this is going to work. Well, they didn't hire you as a business advisor or a marketing advisor. They hired you to be their lawyer. Now, if they ask you, hey, lawyer, what do you think? You can go ahead and tell them. I don't think the world needs another Facebook and we're just going to call it Google Plus and that makes it amazing or something like that. Sounds like a really dumb idea. So you can tell them that But corporations have to take risks and make difficult decisions about product lines and marketing and moving into new areas and moving into new geographical markets and so forth. And you might not like that idea, but that's not your job as the lawyer necessarily to weigh in on that. And so the corporation can make a bad decision from a business standpoint, and you have to let them do that as the lawyer. Okay, and that concludes our first lecture on Model 1.13 or 1.13 about organizations as clients.